Ramadanchi, what is the main argument the other side uses on the warrant requirement? We think there should be a warrant.
Hey, Patriots, welcome back to the channel. Today, we're reacting to something that should have every freedom-loving American sitting up and paying attention. You know, there are a lot of debates up on Capitol Hill that most folks tune out, but this one goes right to the heart of what it means to be an American. I'm talking about our privacy, our Fourth Amendment rights, and the fight over Section 702 of the Foreign Intelligence Surveillance Act.
They have an argument. Can you tell the committee what that argument is?
They will typically say, we have lawfully collected this information already, so we should be able to search through it. The Second Circuit has recognized that the search of a U.S. person's data is a separate Fourth Amendment event that requires a separate Fourth Amendment analysis.
Yeah. I mean, that's their argument. Oh, we followed the law. We were searching foreigners overseas for intel, right? That's what the law says they can do. And they said, we followed the law, so now we can search the data for Americans. And that's the problem. And the court in New York just last year said, no, you can't do that. The court said this. I mean, here's a fundamental question. Tell me if you agree. Should the government be allowed to do warrantless searches of the same information Section 702 says it's not allowed to collect?
The court was very clear that they should not be able to do that.
Right, because and the law says it. You're supposed to collect information on foreigners overseas for intelligence. And now there are people who say, no, you don't need a warrant because we're going to do searches for Americans using their identifiers, their email, their phone number, their name. Well, that's not supposed to be in there. And the court said you can't have it both ways. That is what the other side wants. They want to have it both ways. And they can call it incidental. They can say we're doing a query, not really a search. That doesn't fly. And again, don't take our word for it. The court in New York said so December of last year. Is that right?
Yes, and the court said, like citing the Second Circuit, that simple storage is not enough. And it cited, I believe, Riley versus California, which gave the example of a case where they had lawful possession of a cell phone. They still needed a warrant to be able to search the contents of that cell phone.
Yeah, this is, I mean, we had, the chairman knows, we spent a year debating this within our conference and with our friends on the other side last Congress, and we're about ready to go back into the same darn fight for the next year. But this court decision, we didn't have that last year. And I like the way they said it. They said it would be paradoxical to permit warrantless searches of the same information that Section 702 is specifically designed to avoid collecting. You're not supposed to collect information on Americans, but, oh, we did the search of foreigners and we got some, so now we can search Americans. No, that makes no sense. But that has been the argument year after year, Congress after Congress, and hopefully we can get to common sense. And what the court said, this Congress, and say, time out. Can't do it anymore. And we'll still put the exceptions in, for goodness sake. So to answer their other argument, oh, there could be an emergency situation, imminent threat. Okay, fine. We don't want bad things to happen to America. Fine. You can do that. And if we can't get this passed, it is, I don't know. I was so frustrated because, you know, losing beats, or winning beats losing every time, and a tie is a loss. And that's what we had last time. And we got to make sure we win this time, Mr. Raskin. We need to make sure we win this time. I will yield my time to either to the chairman or to Mr. Klein. I have a minute and 40 seconds left. Mr. Klein.
Now, Congressman Jim Jordan just laid it out in committee. And let me tell you, he's spot on. For those who missed it, here's what's going on. The government, under Section 702, is supposed to collect data on foreigners overseas to protect us from foreign threats. That's the law, and that makes sense. National security matters. But here's the dirty little secret. When they scoop up all that foreign data, they're also grabbing up Americans' information incidentally. And what's the government's argument? Oh, we collected this data lawfully, so now we should be able to search through it for Americans' information. Asterisk without a warrant star dot. Are you kidding me? That is a direct assault on the Fourth Amendment, folks. Let me read you the Fourth Amendment, because I bet a lot of folks in Washington haven't read it lately. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause. It doesn't say, unless it's inconvenient, or unless you already have the data lying around. It says no, period. The courts are starting to wise up. The Second Circuit just ruled that searching Americans' data Asterisk, even if you already have an asterisk, is a separate Fourth Amendment event. That means you need a warrant. Full stop. And Jim Jordan nailed it. It's paradoxical. Makes absolutely no sense to say you can't collect info on Americans. But hey, if you happen to come across it while looking for foreigners, now you can dig through all you want. Let's not forget, this is the same government that told us if you have nothing to hide, you have nothing to fear. That's not how freedom works. Our founders didn't fight a revolution so bureaucrats could rifle through our emails and phone calls without a judge's say-so. And I know what some of the folks on the other side will say, but what about emergencies? What if there's an imminent threat? Listen, nobody wants to tie the hands of our intelligence agencies when there's a real danger. If there's an emergency, if lives are on the line, you do what you have to do. But that should be the exception, not the rule. That's why we have judges on call 24/7 for warrants in emergencies. That's why the law allows for exceptions. But those exceptions should be rare, not a loophole big enough to drive a truck through. Here's what really gets me, folks. Congress has been debating this for years. Every time we get close to restoring true constitutional protections, the deep state, the intelligence apparatus, and their allies in Congress start crying wolf. Oh, we'll all be less safe. Well, you know what makes us unsafe? A government that thinks it can break the law because it's convenient. A government that thinks the Constitution is just a suggestion. We need to win this fight, like Congressman Jordan said. A tie is a loss. If we let them keep these warrantless searches, what's next? If we give up our Fourth Amendment rights, what's left? We can't keep making excuses. We can't keep letting them have it both ways. If you value your freedom, if you care about what makes America different from the rest of the world, you've got to speak up. Call your representatives. Tell them to support warrant requirements for searches of Americans' data. Tell them to stand up for the Constitution. Because if we don't draw the line here, there won't be a line left to draw. I love this country, and I love our Constitution. I want my children and grandchildren to grow up in a nation where their rights mean something. Not just when it's easy, but especially when it's hard. Patriots, let's make our voices heard. Don't forget to like, subscribe, and share this video. The fight for liberty never ends, and together, we the people can hold Washington accountable. God bless you, and God bless the United States of America.